All set, Dave? Thank you. So good morning, everyone. Today is September 12th, one day after we all honored the victims yesterday of 9/11. We'll get started. We are convening the MGC's public meeting, and we're doing so virtually, so we'll need a roll call. Good morning, Commissioner O'Brien.
Good morning. I am here.
Good morning, Commissioner Hill.
Good morning. I'm present.
Great. Good morning. And Commissioner Skinner.
Good morning, Madam Chair. Good morning, everyone. I'm here.
Good morning. And good morning, Commissioner Maynard.
Good morning, Madam Chair. I'm here.
Okay, excellent. We'll get started and calling to order public meeting number 391 of the Massachusetts Gaming Commission. And before we get started on our racing matters, we do have an exciting update from Director Vanderlinden from, I believe, Encore Boston Harbor.
Yes, I'm at Encore Boston Harbor this morning. Good morning, Madam Chair. Good morning, Commissioners. I'm at Encore Boston Harbor for the launch of Play My Way. So for those that are not aware of what Play My Way is, it's a budget setting tool that's available on every slot machine now live at Encore Boston Harbor. Play My Way allows patrons who are enrolled in the player reward card to set a budget, set a budget for a day, set a budget for a week, and or monthly budget. And as they approach or as they meet or in some cases exceed that budget, they're provided with reminders about what budget they had set. And Play My Way is really intended to be provide informed player choice. It's our job to make sure that individuals have the information they need so they can make that informed choice about how much they want to spend and provide them with information so that they know where they stand. They can make that decision whether to continue to gamble or when it's time to stop and walk away. What's unique about Play My Way is, well, there's a lot, but it's a partnership. It's a partnership with our Game Sense program now at each casino as they help roll out Play My Way. It's a Game Sense tool in many ways to help people gamble responsibly. It's also a partnership with each of our licensees, and today it's celebrating that partnership with Encore Boston Harbor through a long journey of the development and launch of this system. It also represents sort of the final chapter that started back in 2016 with the launch of Play My Way at Plainridge Park Casino. So it launched there in 2016. It launched on March 30th of this year at MGM and launches here today at Encore. I'm happy to report that to date, we have roughly 27,500 individuals enrolled and actively enrolled in Play My Way. That does not include individuals who have enrolled and then unenrolled. So 27,500, over 3,000 now, 3,113 to be precise at MGM are actively enrolled since March 31st. It also, I think, is important to note that this is the final chapter in rolling out Play My Way. Now, every slot machine in the state of Massachusetts is enabled with this tool and provides a valuable resource to help people gamble within the budget that they set if they choose to use this tool. And in fact, that's something that I should probably highlight. This is a voluntary tool. You can use it or you don't have to use it. It's voluntary to enroll. It's voluntary to unenroll. So just in terms of a technical update, we are live and have been live here at Encore Boston Harbor since around 4 a.m. It's been tested on random slot machines and is working as it's intended so far. We're still in the process of getting, there's a kiosk right outside the Game Sense Information Center. We're in the process of still getting that up and running. That really is a great tool to allow the Game Sense advisors to assist people in enrolling. We expect, the report is that we expect that to be up and running by noon today. So that would be the only outstanding piece that I'm aware of. So it's good. I'm happy to report this. It is good news for the commission, and it's good news for individuals who wish to use this tool.
Once again, just as in the case with March, we would have loved to have been there with you. In March, we had an important meeting that conflicted. Today, we have a meeting that conflicted, but this is how we have to roll right now. Lots on our plate, but we are all celebrating this important rollout. Questions from Mark, commissioners, or comments?
I don't have a question. I just want to say congratulations to Mark and his team. I know this has been a long haul getting this up and running. I know it's been very successful at the other two, so I'm happy that it's finally up and running at Encore.
Thank you.
Other comments, or Commissioner Skinner?
Just echoing Commissioner O'Brien's comments, I had the opportunity to sit through the Game Sense strategy meeting last week, and heard firsthand how well prepared and well poised Mark and his team and Encore were to launch today. So another congrats to Encore and to Mark and team.
Great. I want to thank Encore Boston Harbor, because it truly has been collaborating with Mark and team to take care of being the third part of this important rollout, and really giving its patrons important responsible gaming tools so that they can make healthy, informed choices. All three licensees, as Mark emphasized, have been true partners in this collaboration, and they are unique partners. This is not happening in other jurisdictions. So that's a credit to your leadership, Mark, your vision, the work that Long does to support you, and of course, all of the support that comes from IT and Katrina's team and from the licensees themselves. So congratulations. And we just hope it's going to be a very successful day. We're looking forward to the number count at the end. Commissioner Maynard, did I skip over you? I'm not sure if you, thank you so much.
Yeah, here. That's all I have to say. Congrats, Mark, Long, and EVH.
Excellent. Commissioner Hill, all set? Okay.
All set, except a big congratulations.
Congratulations.
And I know you're not able to make it today, but it's the commission standing behind this since really 2015 to prioritize responsible gaming in the state, and seeing it through to this point and where we go in the future. There's certainly a lot of directions that we can go as we continue this journey to promote safe levels of play and reduce gambling related harms.
Thank you. Good luck today, Mark. We're thinking of you. And thanks for taking the time this morning. All right, good luck.
Thank you.
We'll move on to item number 3, and we're going to begin with Dr. Lightbound. You have some business for us to take care of today.
Good morning. Our first racing item is the request by the Standardbred Owners of Massachusetts for recognition as the group that represents the Standardbred breeders in Massachusetts. This is in accordance to Mass General Law 128, which is the agriculture section of the law. And they have been the representative group from 1992. Today, I have Nancy Longabotti, the Treasurer Secretary, on, and she can give a few statistics for us. And I'll turn it over to Nancy now.
Thank you, Dr. Lightbaum. Good morning. Just a couple of things looking back at 2021. Our organization has a publicist. His name is Tim Bojarski. He writes daily stories every day after the races. And he also will highlight mass bred performances. He'll do some more in-depth stories as we approach Sire Stakes season. And he also does, keeps the membership informed, payment dates, things of that sort. He's been with us for, I believe, 4 to 5 years. So I think it's worked out well. And some of the things Tim highlighted was last year, we gave away 2.25 million in purses. And we had 3 divisional stake records also, which is very exciting. We had 83 individual starters in 36 races last year. We had 137 broodmares. That was up a little bit. Our numbers had dropped a little from COVID, but we see it getting back up. So that's encouraging. We like that. We're excited for a competitive stake season in the upcoming year. We have 169 eligible horses for the 2- and 3-year-old races this year. We anticipate to be matching the 21 purses. Possibly could be a little bit more than that, but we're at least anticipating to be the same. So we're happy about that. Our races begin on Sunday, September 25th, and our finals will all take place on October 24th. We have all 8 finals on that day on a Monday, and we would love if any or all of the commissioners could attend. That would be great. We always love having them out there for that. And if anyone has any questions, I'd be happy to answer them at this time. Thank you.
Thank you, Nancy, and
You're
welcome.
welcome.
Could you just,
Thank
so that the sire stakes, did I get that right? It starts on September 25th
Yes, Sunday, September 25th.
and goes through October 24th.
Yes, yes.
Okay,
There's Sundays and
Yeah.
Mondays, and then the finals are all 8 finals take place on Monday, October 24th. Because we have 4 races each of the other days for the 3 legs. We do them on 4 races on the Sunday and 4 races on Monday, staggered through, and then all of our finals are on that last day of the 24th of October.
great. Okay, so questions for both on the sire stakes and also for the breeding program for Nancy? Commissioner, is anyone turning off their volume or turning? Oh, right now, Commissioner Skinner.
Thank you, Madam Chair. Good morning, Dr. Lightbound. Good morning, Nancy. Pleased to
Thank
meet you.
Thank you. You
I
too.
think my question is directed to you, Dr. Lightbound, and I apologize that we couldn't connect last week. As one of the newer commissioners, just is this process an annual one? And a more general question would be, what makes this group uniquely qualified to hold this recognition? I did read the statute, but I wasn't able to find any other information that really details and discusses what's required to hold this recognition, and really what it means generally. So if you could shed some light on that for me, again, as one of the newer commissioners, I'd appreciate it.
Yes, so it is an annual vote by the commission per the statute. And this is the only group that has come forward to be the group. And like we said, I don't remember exactly what the original qualifications in 1992 were for them to receive the go-ahead from the State Racing Commission at the time. But again, they have been doing it since that time period. And, the program has always been handled well, and they've worked closely with the track. And with the Racehorse Development Funds, the program has only developed even better.
Thank you.
Commissioner Hill, are you leaning in? Are all set? Okay. Any further questions? Just on the breeding, so you said that there are 169 horses this year. Are you?
Yes, eligible for the 2- and 3-year-old races. Yes.
And for next year, how are you feeling about the breeding program, Nancy, overall?
I have a good feeling about it. Obviously, because of the money, the funds
That's
from
what
the
I'm
Racehorse
wondering.
Development Fund. of course, that's helped it, so much. And we've had there's been a lot of interest. It used to be more of kind of the same people that were involved, but it's branched out, with a lot of, new interest, new people, new breeders. So, and some bigger farms from out of, from New York, New Jersey, things like that have wanted to get involved in our program, which is obviously good because they come into our farms in this state and helps with this economy, this agricultural economy. So we feel good about it. There's a few changes we'd like to make and some things we'd like to do. And I think we have a few projects that we'd like to do going forward. As with everything, COVID we had some ideas of different things and it kind of slowed everything down, unfortunately. But I think, as I said, the numbers are picking back up. So we do have some ideas about, promotion things, and hopefully we like to do a video that we like to present from our group. So I think we'd like to possibly do that next year, because that's ideally what we like to do, is then we present the video at this time. Usually that's what we've done, but we are looking to do a new one. So that's kind of something we'd like to do as well. But we feel good about it. I mean, the numbers are really good. As I said, they had gone down a little bit, but came up last year. So I'm anticipating that the numbers should be good. They didn't drop off exceptionally, but just a little bit. That was kind of to be expected because of COVID. So I'm excited to see this year's numbers. I think they will be good. I do.
Yeah, I had wondered if there was a way to gauge it, but it sounds as though, Dr. Lightbound, is that the Horse Racing Development Fund is effective here.
Mm-hmm. Very.
Yeah.
Yes.
Okay. All right. Well, I appreciate your coming today, Nancy, and giving us your update.
Thank you for your time.
Thank you very much.
Thank you for having us.
Yeah. Dr. Lightbound, do you want to add anything, in terms of the breeding and the numbers? Any further insight on that you want to add?
No, as Nancy mentioned, the competitiveness of the races has really increased over the years recently, and it's been exciting to see. And also the field sizes have grown, and some of the divisions actually needs to be split into 2 races because they've had enough horses to fill 2 races for it. So that's been really exciting to watch the program benefit that way. And my recommendation is that the commission approve this request.
Right. I'll need a motion because I know that you need a vote. Commissioner O'Brien.
Certainly, Madam Chair. I move that the commission approve the request of the Standardbred Owners of Massachusetts, Inc. to be recognized as the group of representative standardbred breeders to administer the Massachusetts Standardbred Breeding Program and the Sire Stake races for 2022.
Second.
Any further discussion? Okay, again, thank you to Nancy, and thank you, Dr. Lightbound. I'll take our roll call vote. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. Thank you. 5-0. Congratulations to your association, Nancy. Thank you very much for your work.
You're very welcome. Thank you for your time.
Thank you.
You're welcome.
Okay, now we're going to move on to the second part of our racing update. This is work that reflects earlier public meetings and ongoing discussions, none of which are uncomplicated. So I'm going to turn it right to both the Executive Director Wells and General Counsel Grossman to lead the discussion. In our packets, we received what I understand to be our draft application, which is a clean version, but I understand the red line document to be strictly the edits that we discussed at the last meeting when I led us through all the public commentary, if you recall that meeting. So the red lines would be reflective of just those edits. Todd?
Yes, thank you, Madam Chair. Good morning, everybody. Before you today, as the chair just mentioned, is the draft application for the new license to conduct horse racing that was previously reviewed by the commission at the August 17th public meeting. You will, of course, recall that there were a number of comments offered by commissioners at the time, as well as a series of public comments that were received. Those issues have all been addressed in the updated draft that you have before you, and that we will review this morning. Momentarily, I'll turn the presentation over to Deputy General Counsel Caitlin Monahan, who will walk through the application and review those amendments. At the conclusion of the review, the commission may elect to approve the application for formal use, and if so, it will be promptly posted to the commission's website in advance of the October 1st statutory filing deadline. By way of brief refresher, you'll recall that the contents of the application itself are generally addressed in the racing statute, which is Chapter 128A, Section 2. And similarly, there are parts of the application that are specifically authorized by way of a number of court cases. Both of those authorities are referenced in the application itself so that all involved are aware of the source of the commission's authority in navigating this process. Certainly, we can discuss these authorities as we move through the draft. So with that, without further ado, unless there are any questions.
I do want to interrupt briefly. Commissioners, you also received an A&K privileged memorandum that went through the legal issues that, of course, we have received briefing on in the public as well as somewhat in the silent briefing. Paul Commoners, thank you, Paul, for joining us at the last minute. I had noticed that you weren't on the agenda, but I did want to make Attorney Commoners from A&K Anderson Krieger available to us in the event you have any questions based on the memorandum that supports today's discussion as well. If in fact we are not going to have any questions for Paul or at any point in time, just we can figure it out and excuse him. Paul, do you have some parameters on today's in terms of when your availability would be?
Good morning, commissioners. I'm available to you for however long you need me.
Okay, thank you. Thanks so much. And good morning. All right, so go right ahead then, Caitlin. We appreciate the presentation.
Great. Good morning, everyone. Unless anyone disagrees, what I would like to do is I'll walk through the red line and just briefly point out some of the changes that were made based on our last conversation. So I'm going to share that.
Caitlin, would you mind also maybe reminding the commissioners of some of the issues too as we go through this application? It's been a very disjointed discussion, and I know the other commissioners may be really comfortable with where they are. I need that additional assistance, so thank you.
Absolutely, happy to do that. All right, so we start at the beginning, just the introductory information, of course, who the applicant is, where they plan to hold a meeting, and when they submit the application. Then this section here relates to the two different monetary requirements: the fee that must be enclosed, it's $300 fee that must be enclosed to the application, and then the requirement of a surety bond that must be issued and included with the application. Section 1 is just the background information for the applicant. So again, pretty standard information about who the applicant is, what kind of entity they are, their mailing address, et cetera. And a lot of these pieces are required by statute. Section 2 is the project summary and financing for the project. So this section requires the applicant to include a description of the proposed premises and facilities, and then it gets very granular on what is the grandstand going to be enclosed? Is it going to be heated? What's the seating look like? So that the commission would have a very good idea of what the actual facility will look like before it votes on whether to grant a license. And down here, this red line is just that we had combined two questions that were basically asking for studies that had been performed about the project. So
Caitlin,
section
I'm
three-
going to just interrupt briefly. Commissioner,
course.
do you want to ask questions along the way, or are you more comfortable holding it's a long application? How should we proceed?
I think
Eileen?
along the way makes the most sense. I don't have any at the moment, but I
No.
would think along the way makes sense.
So
Agreed.
Absolutely. I apologize if I didn't pause, but please just jump in if you have anything.
Commissioner Hill, any?
Yep, agreed.
Okay, so of course I can't see everyone's faces because we're, have a document in front of us. So just, Caitlin, you'll forgive us if we interrupt,
Of course.
okay?
Yeah, just
Thank
shout on
you.
out.
Thank you.
All right, great. Section 3 is a schedule of proposed races. Excuse me. And so this is, again, some statutorily required information about when the races will be held, the days on which they'll be held, the times on which they'll be held. This all needs to be included in the application. We also added this question here in 3.1 that is directed at applicants that may be seeking a license for future years. So for instance, an applicant this year seeking a license for 2024 or 2025. And it basically gets to that what it's asking is for additional information about how they're going to meet the timeline they're proposing and why they think that they'll be able to run races in 2024, 2025, et cetera. So if anyone has any questions about that, I'll pause for a second.
So I think that that's a good question to maybe for us to tease out again for the public's purpose. This would allow for us to address those races well into the future. I know that, Paul, you've addressed this in your memorandum, and it might be helpful for us to just go through why that's okay.
Certainly. It's really based on a straightforward reading of the statute. The statute provides that a license request must be received on or before the first day of October of the calendar year of.
We've got the language in front of you because I know that you were just invited. So I know I'm putting you on the spot, but I also know if there's somebody who can be put on the spot, it's Paul. So thank you and be able to help us out. So thank you. Have you got the language in front of you
On or
now?
before the first day of October of the calendar year preceding the calendar year for which the applicant requests a license to be issued. Putting in an application on or before October 1st of any given calendar year not only precedes the following calendar year, it precedes any subsequent calendar year after that. So if I were to submit an application for a racing license today, it could be, on or before. It could precede 2023. It could also precede 2024, 2025. And so forth. We are not aware of historical practice of anything like this being a historical practice of the Commission, but circumstances have also changed dramatically since racing was first provided for in the Commonwealth. There are at least two major ways. One is in the past, there were operating racetracks that could use a license for the next calendar year immediately without having to go through a construction phase. The other is that construction and permitting take much longer now than they used to when Suffolk Downs was famously built in a matter of months. Given those changed circumstances, the statutory language and the Commission's broad authority as the administrative body charged with interpreting and applying and implementing the racing statute, we think that this interpretation is well within the Commission's powers.
Thank you. Any questions for Commissioner O'Brien? I see you.
I do. So I follow along. My hesitation comes from the fact that the choice of language in the statute says the calendar year preceding the calendar year for which application requests the license, not a calendar year. And so with the theory being that statutory interpretation, every word, of course, choice is significant. Can you speak to why the fact that it says the instead of a calendar year is not troubling to you or is not dispositive?
I think that creates ambiguity, but I don't think it's dispositive. I'm not sure that the use of an article would bear that dispositive weight.
I guess I'm not quite there with you. I see where you're coming from. I didn't know if there was any other force of law to back that up, but thank you. Thank you for your answer.
Other questions for Paul on this? So Paul, Suffolk Downs, when it opened, was it operating under the same legislative language? I don't know.
I would need to confirm whether that statutory language has changed. I'm not sure.
Okay, thanks. And in terms of I think I'm all right on that issue. It's a little bit different than our casinos because this is really not about just construction. It's about the horse racing itself. All right. Any further questions? We need to really there is, of course, a deadline looming. And so we want to get comfortable with all of our questions this morning, commissioners. Okay.
There again.
Caitlin, if you want to continue and if you want to shed any light on that matter, please do.
Absolutely. I think Paul covered that nicely, and I think we agree with that interpretation regarding future years. That is not to say that the applicant wouldn't have to provide sufficient information that they could actually operate in that future year, and the commission wouldn't have to be comfortable with that. But we do believe they could submit an application for future years. So moving along down to section non-commission approvals. So this gets into the statutory requirement for approval in the local community in which the racetrack is to be located. As you may remember, the Board of Selectmen or the mayor has to approve there being a racetrack in that community before the application can move forward. And that's under section 13A of 128A. We added some additional language in here, just getting to questions of, if the approval hasn't been received yet, is there a vote scheduled? What is the anticipated plan there? Because again, this is required. The commission cannot issue a license, even a conditional one, without these approvals in place. Then there's sort of a mirror section for section 14A of the statute, which is county approval. There has to be a vote in the county in which the racetrack is to be located, approving horse racing. Again, that has to be in place before any license can be granted. So that's section 4. Any questions?
That's 4.5. Commissioners, just several red line changes. Have you all had a chance to look at them? If not, just take a moment.
I think we wanted to be very.
Possible to make it a little bit. Oh, sorry. Go ahead, Fred.
Go ahead, Commissioner Hill.
I was just going to say, I think we were all very concerned that we wanted to make sure the applicant knew exactly what we were trying to get at. And I think the new language does that.
You're happy with 4.4. That's what I'm looking at. Have there been any votes taken concerning the proposed project by any governmental entity or the voters of any governmental entity, including but not limited to the host and surrounding nearby communities in which the proposed project is to be located? That's pretty broad.
I'm okay with that.
Yeah,
that is, Chair, that's intentionally broad.
Yeah, so no, we want that.
Yeah, okay, yeah.
Yeah, we want that. It's
in case any other entity had voted that wasn't the Board of Select people or the mayor or whatnot.
I think Commissioner Hill was commenting that at our last meeting, how important it was for us to make sure that the local regional communities were heard. So I think that language is more than broad enough, right? So, anything else? And then 4.5 is that county vote. And I think we learned this even from our last year's experience. For those, I think it just would have been Brad, Commissioner Hill, Commissioner O'Brien, and me, but those county votes stay valid, correct, Paul?
That's correct.
Curious.
All right, I'll move on.
And
unless there's
now I
other-
just want to turn back to Director Wells. You were going to offer something, Karen?
Oh, I was actually just going to ask if we could make it a little bit bigger. I was just having a
Oh,
little
sure.
I did grab my glasses, so I'm okay.
Well,
I
it would
apologize,
be
Karen. I'll
very-
make that bigger.
It would be very helpful. Yeah, thank you.
There
I've got my paper
we
copy.
go. Whoop, there we go. Is that better?
There we go. Thank you.
Great. Okay. Okay, then. So moving on
Okay.
to section 5, which is qualifiers and suitability. And again, as Todd mentioned, the ability to, or the requirement, in fact, to look at the suitability of an applicant for a racetrack license comes from some case law from the SJC, and it's cited here. And so we had a conversation at the last meeting about how the commission would like to define qualifier for these purposes. And it was decided that because there is now a connection between horse racing and potentially sports wagering, that connection being that someone who has a license for racing may apply for a sports wagering license, we wanted to try to marry up the definitions of qualifier. And so I spoke with the IEB, with Loretta and with Heather, and they have put together this definition of qualifier for the purposes of racing that we also anticipate will be used for sports wagering. Again, while the definition for the purposes of sports wagering is not finalized at this point, we could update this application next year if it changes at all. So at this point in time, this is our best estimate of what that definition will look like. Does that make sense? Any questions on that?
Is there any way we can add language that would reflect that's a kind of an escape language or a catch-all that would, for this year, if our deadline on these applications we will be looking for October 1 submission. If there are any applications that come in, I believe our deadline is November 15th.
For responding.
So if there's any way that we could say some kind of and I don't have the language in my head, Caitlin, forgive me, but would in other words, it would reflect what we decide for sports wagering this year, and so that there somehow isn't any inconsistency between our decision, or if we have to make a decision by November 15th.
I suppose we could. The difficulty would just be in the timing if the definition changed dramatically. That the application has to be in by October 1st and then has to be decided on by November 15th. So we're only a couple of weeks away at this point. But we could put that language in and then update the applicant that we would need some updated information.
And isn't that covered in 5 of that section?
I'm sorry, Commissioner, can you just direct me to what you're referencing?
What the chair is suggesting is that not covered in paragraph 5 there, or?
Well, there is the ability to add people to a list of qualifiers, certainly. So yeah, I think that could be, I think that's exactly spot on. The commission has the ability to add qualifiers, and I suppose could also remove some. Well,
What if we said
it would
something to that effect, like or as otherwise, or also to include such qualifiers determined by IEB. It shouldn't be a problem.
I think that if you look here where my cursor is, subsection 6, that's pretty much it. The Division of Licensing, after consultation with the Bureau, may at its discretion require other persons that have a business association of any kind with the applicant to be subject to the qualification requirements as a qualifier.
Okay, so then in fact, we don't have to worry about any inconsistencies between now and next year.
I think that's right. And again, we can always modify this in a year if we had to.
I'm looking for with that. Yeah, that's really Karen,
Madam
you've
Chair,
got a lot of
is-
experience with this.
Yeah, I
don't
was
you?
just going to say that is consistent with how we've done that in the gaming side of the house. I would expect we'd have the same thing in sports wagering, so these would all match up as I read it.
Good. And if there's for any reason that we have to add some kind of other language because of something that we can't predict, then let's do that. Just because I'd rather not have any inconsistency. But this does, as I look at the language, it seems to really plan for any expansion.
Great.
Okay.
All right. So moving through this, this is
And
no
on
more.
yeah, and again, just to turn to Paul, you gave us some advice and consistent with what Todd led with. Is there anything you want to add on our ability to perform suitability with respect to these qualifiers?
I'm happy to answer any questions that the commission has, but the simple answer is that the commission has long recognized statutory authority on the face of the statute to ensure the suitability of qualifiers, and it's consistent with the reasons that reasons repeatedly recognized by the courts that the legislature enacted the entire racing regulatory scheme.
Thank you. Okay, Caitlin.
All right. So you'll see a lot of red lines here. This was actually one question before, and we got a helpful comment that it might be nice if we separated it out. So it's the same question you've seen before, separated out into several additional questions. Again, these are all questions that get to the suitability of the applicant.
Any questions, commissioners, on those? Karen, anything that you see?
No, that's consistent.
Great. So then we move into section 6.
Sorry,
Caitlin,
I'm sorry. Just before you move on, are we the entirety of 5.9? Like, are we on to, can I ask you about 5.9?
Oh, please. Yes, anything.
Okay. So it's limited to revoked or suspended by any governing authority. Is there any chance any other endorsing authority, like, is there any way we're hemming ourselves in with governing authority as the verbiage there?
The way I envisioned the word governing authority being used was whoever has the authority to issue the license or allow the entity to, engage in horse racing. But if we think that language is potentially to be interpreted in a more restrictive way, we can change it.
Well, I'm wondering is if we say has applicant or any of its qualifiers ever had a gaming license revoked or suspended? Question mark.
Okay.
Does that take out any chance that someone could be cute on? It wasn't an order; it was a recommendation.
Yeah, I think that would get to it, and again, would to your point, would avoid the cuteness. So yeah, I think we can do that.
All right.
Okay. Any other questions on section 5? And I think I could do the same thing down here, Commissioner. So, that was denied, period, not necessarily by a licensing authority. I'll go through and make those changes.
And Commissioner O'Brien, are you, and again, I apologize if I've missed this elsewhere, are you mainly concerned about revocation or suspension, or are you also concerned about withdrawal at the time of application?
You mean in terms of the word choice I just talked about, or?
No, I'm just wondering, and it might be a separate section. I know that we, of course, are concerned about revocation or suspension. I wondered if you were at all concerned about, have you withdrawn your application?
No, I think it's a valid question in that same vein. So whether it's rolled in there or whether it's separate, that's a good idea.
And it may be a very legitimate explanation for withdrawal.
Right.
Yep, I can add that in there, in that same section. Great. Okay, so down to the public interest now. And again, the statute itself says that the commission will consider the interest of members of the public in racing competition honestly managed and of good quality. So that's why we have a series of questions here that get to the public interest in the racetrack. And I'll point out some of the changes that we made pursuant to the last conversation. So here's section 6.6 is the labor harmony question, and we took this from the RFA2 language. And so this, the applicant will have to sort of explain how they're going to be working with labor in their processes. And then section 6.7 is the result of some comments we received from the public, and it asks the applicant to explain any promises they've made with regard to putting the racetrack together, promises, mitigation agreements, whether formal or informal, so that they're held accountable for that.
Caitlin, I guess this is my prosecutorial days coming back to me.
Yes.
But the wording I was always subjected to and put out was promises, rewards, or inducements.
All right. I like it.
I recall that.
Yeah. I was subject to that question, and I asked
I'm very familiar with that.
Yeah.
Great. I can make that change.
So those two, just as a matter of procedure, both 6.6 and 6.7 came directly from important public input. So again, we appreciate public's participation as we work on this. Thanks so much. Okay, section 7.
We get section 7 deals with facilities and equipment. And again, this relates to sort of keeping people safe while they're at the racetrack and maintaining proper facilities for the race meetings. These are largely similar to what you've seen previously. I did add one question here about whether the premises is held or owned by the Commonwealth or any political subdivision thereof. That comes straight from the statute. If the land is held by the Commonwealth or a political subdivision thereof, there can't be a racetrack on it. So it's an important question. It's just helpful to get a straight answer to that rather than having to review the materials ourselves. Again, not a ton of changes in here. And then we did add an important question here at 7.8 about the applicant's plans to ensure the welfare of horses on site and their aftercare as well. Any questions?
Pause. Dr. Lightbound, are you all set with this so far? We haven't, I'm assuming that she's right there. I just don't see her face.
Yeah, I'm good. Thank you.
Okay, excellent. Any
All
questions,
right.
commissioners? All right.
Okay, moving on to section 8, wagering and simulcasting. So again, this is very similar to what you've seen previously with regard to questions about wagering and simulcasting. We did add language in section 8.2 here that reflects the language in actually it's not in 23N, it's just an amendment to 128C related to the number of race days that thoroughbred tracks would have to conduct in the future. And that does not take effect for a year. And we note that, but we wanted to make sure it's in the application at this point in time. Any questions on that?
I'm just looking right now as to whether, Paul, you provided any advice on this particular provision.
I believe we covered that in the second footnote in the updated.
Yeah,
memorandum.
the second footnote. I'm not seeing. You mean a second, the second section? Is that what you mean? That's a boarding recent meeting. When you're out.
I have it at the bottom of page 6 of my copy of the memorandum.
No, let me see. Thank you. You're with me, everyone. Yeah, that's not what I'm seeing in the memo I have.
It's not a footnote. I think it's more just in the body.
Yeah. Okay, let's continue. Thank you for
All right.
giving me a time to think.
Okay, I'm going to share again here. Okay, and then we move on to the last section, which is general conditions, attestation, and signature. So these are some of the conditions under which the license is to be issued. The applicant must make certain attestations and certain signatures. And again, a lot of that is prescribed by statute. So there really weren't any changes to this section at all from our last meeting. So that is, I'll stop sharing to take questions on the application as a whole.
Questions, commissioners? Questions for Paul as we have gone through some of the bigger issues. Maybe I should ask General Counsel Grossman, we operate in a public forum. The only way we can get legal advice and be able to chew on it together is in a public forum. So I guess I am asking, should every commissioner feel comfortable referencing Paul's memorandum? Well, it's a privileged document to each of us. In order for us to really think about the advice, can you give us some suggestions? We don't even have an executive session available to us to discuss the advice.
Hit the nail right on the head, Madam Chair. There is really no great way for us to share or to discuss legal issues outside of the public meeting, other than doing so in writing, as we have done. Of course, that doesn't lend itself to any question and answer or further discussion, which leaves us here in this public forum to discuss certain issues that may be front of mind.
So last week we had one of Paul's colleagues go over legal advice comfortably. I guess I would say that to the extent you have any questions, commissioners, it's most important for you to ask. If you have questions that would benefit all of us, I would welcome them. Commissioner O'Brien?
I don't have any further questions other than to say, I guess, procedurally where I am today, moving forward on finalizing the application is, I think, acceptable, notwithstanding my reservations on the question that I had in terms of the A versus the. I don't think it forecloses us from moving forward on this today.
If I may, I believe I can also offer a slightly crisper answer to that question that may address your concerns, Commissioner O'Brien.
Mm-hmm.
The critical point is that the date of receipt of the application be on or before October 1st of the calendar year preceding the date for the year in which the applicant intends to hold races. An application received today is on or before October 1st, 2022, also October 1st, 2023, also October 1st, 2024. And accordingly is received on or before October 1st of any calendar year, at least 1 year out. And that's why I don't believe the use of the or the preceding calendar year is definitively states that the application must be for the following calendar year, because the date of receipt is always in line with what the statute calls for.
No, I hear that. I'm still processing on it, but sorry, I see Karen had her.
I've got Director
Yeah,
Wells.
so I'm sort of following. I was thinking along the same lines as Commissioner O'Brien, and I guess I just want to make sure the commissioners are receiving the correct information. My understanding is that the way the application is drafted, there's a couple of issues. One, there's through the question 1.8, there seems to be an opening to apply even if you're not in Suffolk County. And then through 3.1, it's an opening to allow a license even though the racing wouldn't take place that year. So I guess my question, which I think is what Commissioner O'Brien may be getting at, is by accepting the application now, does that lock in the commissioners to making decisions on those two issues, or it just opens it up that's open for discussion? And when they make the decision on the 15th, is that the date that they would decide that? Does that make sense?
Yeah, I think I think I understand the genesis of your question, and I would say that absolutely, it does not. Putting out the application doesn't lock the commission in, but we don't want to send mixed messages, right? So if there's real concern about that, then we should try to resolve it as soon as possible and not put the application out and then turn around and say that we are uncomfortable with that. So it's a great question and one worth contemplating before moving forward. But yes, or I should say, no, we're not locked in. I would just add one thing to what Paul described, and I think Paul did a really nice job walking through the actual language of the statute and constructing it. There's a couple of legal principles that may be useful here that at least I find useful when trying to navigate this specific issue. And the first rule of statutory construction is that we are directed to read statutes in harmony with one another to the best of our ability, even if there are some that may be considered in conflict with one another on their face. When it comes to the racing statutes, there are a couple of principles that emerge, I believe. The first is that the licensing of a new racetrack and awarding a new racing license is discussed in the statute and is entirely permissible. And there is no reason to believe that the law was designed solely to be able to renew existing licenses. A read of the statute, and we can point to different provisions if helpful, but and we can go through that, but it does seem to clearly contemplate that a new license may be issued. The flip side of that is that there is no clear mechanism to be able to take in an application that will likely contain a lot more information and require a lot more thought than the renewals that the October 1st and November 15th deadline section contemplates. And it's because of that that we land on a point where we say that, well, in order to be able to license a new track, we need to understand that it's likely to take more than from November 15th to March to build a new facility. So how can you possibly do that? And that requires the commission to exercise some discretion and to read all of these statutes in harmony with one another. And so, Commissioner O'Brien, your point about the word when referring to the calendar year is certainly right on point. It's one that I think we wrestled with quite a bit. But I think when exercising the commission's discretion in conjunction with the idea that there are not a lot of great alternatives to reading the statutes and awarding a new license, that's where this interpretation emerges from, and I think stands on solid ground. So the other factor, of course, to bear in mind is that the governing agency, at least in the first instance, is generally afforded discretion to interpret the law based on its own expertise and understanding of the landscape. So I think we are applying all of those principles as we try to navigate this situation. Otherwise, it would be difficult to award a license to any new operator for a track that will not be operational for a couple of years. I think it goes without saying the difficulty a developer and operator would have constructing such a facility without any indication as to whether they would be able to make use of it in the future. So all of these things together led to this proposal before you, which we do believe is on sound legal footing.
So Commissioner O'Brien, you've indicated that your willingness to move forward. I guess I think it's important to just that for our purposes and the public's purposes, the implications of the application. We did look at a new applicant last year, right, Todd? We had an applicant that applied on our current application for a new license to and we heard it. We recognized the weakness of our application. So a lot of these threshold legal issues we wrestled with then, but we did get comfortable moving ahead using the old application. We're lucky that we had the opportunity to address that, and that's been this process that we've gone through. It's really what happened in the past was that the applicant ended up withdrawing, so we didn't have to make a decision. So we took the advantage of the time to revise our application to appropriately address a new applicant. In the meantime, there has been a new development, and that is the passage of the sports wagering law. And so I think it would be really helpful for all of the commissioners to understand. Commissioner O'Brien, Commissioner Hill, and I were part of that discussion last November, I believe, right? And now we welcome the input on the implications of that, and then of the sports wagering law being passed. There's also issues around simulcasting and whether or not, how that's tied into horse racing and simulcasting. These are issues that probably we should understand a little bit better before we put this discussion to rest on the application. Commissioner O'Brien, do you want to help me out? I was less than fluid, but bottom line is...
I think it's an area that maybe Paul can help. Not only our fellow commissioners, but anyone watching today in terms of discussing the topic you just raised.
Yeah, that's right. These are big developments with fundamental questions that this application process could impact. So Paul, again, just so everyone understands, we literally called Paul at 9:26. So we appreciate your ability to come right in and be able to respond. I know that our own legal team is fully equipped to also answer these questions, but we do have some benefit of your analysis. So thanks, Paul. So simulcast and sports wagering.
Certainly. On simulcasting, I assume the main question is the effect of the provision that Caitlin referred to earlier that was passed in the same act that passed the Massachusetts Sports Wagering Act. So this added a new section 9 to chapter 128C, which concerns simulcasting. And under that section 9 provides that notwithstanding the rest of 128C or any other source of law, a running horse racing meeting licensee shall conduct not less than 20 live racing days at a thoroughbred horse racing track, or to paraphrase, fewer if the commission decides that that is necessary for the financial development of the track. Our best read of this statute is that it is meant to revise the number of races that an operator needs to conduct in order to be considered to have held either a racing season or enough live racing days during a year to be permitted to simulcast. It does not directly amend those provisions, but given the use of notwithstanding, given it that it says that it takes effect notwithstanding the rest of 128C, and given that it was placed in 128C rather than 128A or anywhere else, we tend to think that that is what it is driving at. There are still restrictions on a licensee's ability to, we believe there are still likely restrictions on a licensee's ability to simulcast because this new section 9 did not directly amend the requirement contained in chapter 128C, section 2, that simulcasting take place only on a calendar day during which an operator conducts a racing performance, dark days, which can only take place during a racing season, or dark seasons, which can only take place between racing seasons.
So the conclusion is,
The conclusion is it is best read as changing what constitutes a racing season, but not changing the fundamental, but not changing the other requirements for a licensee to simulcast.
okay,
I have a question, Madam Chair.
sure, thank you, Commissioner Maynard.
So I'm reading 8.2 in the draft application. How are we practically supposed to take 8.2 if an applicant comes in, say in October? Are we supposed to look at the law as it currently stands? Are we supposed to expect any applicant to say, well, we're not going to be operational until after August 10th, 2023? I mean, how are we supposed to read this in light of this?
I can take that. I think you have to look at the year for which the application is being sought. So the provision that Paul was just talking about, which I think the shortest possible way of explaining what it does is changing the requirement that a racing licensee race 100 days in order to simulcast to allowing a thoroughbred racetrack to race for 20 days and possibly fewer and simulcast. So if, because this doesn't go into effect until middle of the year next year, if a licensee or if an applicant was looking for a license for 2023, I think they would likely still have to operate under the old rule, with possibly some change based on the change in the year. But going forward after that, 2024, 2025, they would be operating under the new statute, which would allow for fewer race days in order to simulcast. Is that helpful?
Well, I'm just thinking to myself, and what I'm teasing out with my fellow commissioners is we have two applicants, one that says we are going to hit X amount of races, and then the other one that says, oh, we're going to, try to get 20 or less. I mean, I think we would have to weigh that, going into it. But yes, Caitlin, you answered my question. I'm being a little pithy here.
It's all good.
Okay. One fundamental question is, can you just get a simulcast license from us?
No.
No, the answer to that is clearly no.
No.
Okay, now, the implications of sports wagering.
So the critical point for, I think, your purposes right now is understanding when a horse racing licensee is enabled to conduct sports wagering on their premises. And for that, we can go into the statute and see that the definition of a Category 2 license is one that permits sports wagering in person on the premises where live horse racing is conducted. And I think the use of the present tense is critical there. It does not say that you can post sports wagering where live horse racing was conducted or where it will be conducted. It has to be premises that are being used as racetracks pursuant to a license from the commission. I believe they could seek a Category 2 license earlier, but the Category 2 license would not permit wagering until the track was in active use.
So that would be a condition, in condition. So we could award, even though they don't have an ability to conduct live horse racing because a track hasn't been built, they can't start engaging in sports wagering until there's actual horse racing.
That's what
What about the online wagering or mobile wagering that's connected to the Category 2? If an applicant says to the commission, yeah, I know we have to build our track, we won't we won't do in-person betting, but we'd like to go ahead with online wagering. What's the answer to that question?
I would have to confirm this, but I believe that online wagering would take place under the Category 3 license associated with the Category 2 license, not under the Category 2 license alone. The Category 2 license permits sports wagering on particular premises.
So I know they
You
have
mean
to be
because it's
licensed.
tethered, it tethers, you got to have the Category 2 license first, which requires live horse racing.
Okay.
And then your Category 3 would be contingent. Is that, I think, under the definition of category? I forget where it is in the new statute.
Yes. So a Category 2 license, to operate sports wagering under a Category 2 license, you also must have the mobile application or digital platform that you plan to use qualified for and issued a Category 3 license. I don't think that there's a timing requirement there. You could probably seek Category 3 licensing for your mobile application on a separate timeline, or you could partner with an existing Category 3 operator. But that would, to answer the executive director's question, that Category 3 licensing process is simply independent. It can be treated as independent of the Category 2 licensing.
Actually, I think we want to back up on that. That's a big point.
Yeah, I was going to say, Karen, I actually personally had not contemplated separating them in that way. So I would like to go back and take a look at the statute and think about that a little bit before we reach a final conclusion today, if that would be okay with folks.
Just so I'm making sure that I understand what I think the topic is, because I'm weighing in. If the question is, right now we understand that an applicant, if there is an applicant that comes to us this year, that they would not be able to do in-person retail a sports book in advance of live racing. Is that fair? Okay.
That's correct.
So the second thing, the question that Karen asked, which is a good one, could that applicant, if awarded a license to through our process, could they engage in through either on their own, depending on who the applicant is, or through an operator, conduct mobile sports wagering under the new statute? And what I'm hearing is there's some ambiguity, who maybe are legal, and Paul. But Paul, did I misspeak when I said, don't you have, isn't it? Help me out. I was in law school a long time ago. What is it? Condition precedent that you have to have a Category 2 license first in order to be eligible for a Category 3 license? Condition precedent, right?
I think it's a condition precedent. Although contracts is not my best 1L class.
You know what though? Your best is pretty top notch. So condition precedent. Am I right? And what I'm saying is, do you have to have your Category 2 license? And can a condition one be sufficient? And maybe that's the issue. Could a condition one, meaning conditioned on live racing, be sufficient to trigger a Category 3 license? Is that the question?
Caitlin and I should look at the timing issue offline and follow up with the commission, I believe. The other piece of the answer, but the piece of the answer to the executive director's question that I think is reasonably clear, is that a request to conduct off-site mobile wagering by the same operator would be under a Category 3 license, not the Category 2 license.
Yeah, okay. Paul, you're losing me though, because the only way that they're not one of, are you saying one of the ultimate seven under Category 3? Or are you saying through their tethered category 3 license?
If they were one of the 7 under the category 3,
Well, that's,
or if they
that's-
partnered with one of the 7.
so that's conflating a few things. And can I just, I guess there's anyone could always be eligible for applying for, I mean, not anyone, but we're really looking at an applicant to the license in front of us this fall for horse racing. So if we look at them on an individual, just what will they have access to if we were to award a license? And again, we don't know if we're going to get an applicant, so this may be a little bit of an academic exercise. We went through it last year, so not necessarily totally academic. If in fact we have an applicant or more in response to the deadline that's approaching, we understand that they will not be able to have a sports book until there's live racing. Do we not know right now whether they would have the ability through their right to a tethered license, if it's a conditioned license because they won't have live racing? We don't know right now whether or not they would be eligible to operate a mobile.
I don't believe
Right.
there is
Upon issuance of our license. Pardon
I
me?
don't believe there is a right to the tethered category 3 license, but
Could you say that one more time, Paul? Because it was one word I couldn't hear.
looking at section 6, the commission shall issue a category 1 license to any holder of a gaming license, shall issue a category 2 license to any holder of a license to conduct a live horse racing meeting, and may issue a category 3 license to any entity that offers sports wagering through a mobile application or other digital platform. I would prefer to run this down offline in partnership with Todd and Caitlin.
Yeah.
But I believe the category 3 license, even if tethered, is still discretionary.
Okay.
Yeah, I
Okay.
think that makes sense. I don't think we want to necessarily decide. It's a complicated question. It's a big question. It's very important, obviously. So I think we want to maybe spend a little more time working through that.
Yeah, I think it's a pretty big question. So what we will want to do, Karen, is there is an application that needs to be available for any interested party. We always have the old one available. Hasn't proved to be as helpful. I think this issue might be separate and apart from the application in and of itself anyway. But I do think that it's important for the public to understand what the stakes are in this application process, right? And if it does in fact mean that a successful applicant would be able to stand up its operations, it's for a mobile operation at the same time as other mobile operators, then we want to make sure that's clear before the deadline. So, Karen, I know that you and I spoke a little bit briefly about the process to address this kind of an issue.
Yes, and I also spoke with General Counsel Grossman briefly this morning. Commissioners, I know there was some talk of this at the agenda setting meeting, but given the advice from Anderson and Krieger last week, or I guess was it last week? Although the weeks are blurring a little bit, on the added protections of things being done by regulation. A suggestion for today is that you approve if you so choose, approve the application so that interested parties have the opportunity to get moving and approve and work on submitting the application, but that we put between now and October 1st, we put on a regulation which would cover the application. And I'll defer to General Counsel Grossman on an exact time when we could get that done. But that may give the commission just some extra protection on the issue. And given the advice of Anderson Krieger, that may be helpful.
Madam Chair,
Commissioner Skinner?
I'm hoping you'd allow Executive Director Wells to repeat her question, just so that I'm clear on what the issue is and
Thanks.
sort of the request to A&K to come back to us with.
So my question, I have been looking at the statute while the commission has been speaking. My question was, if you have an applicant, so XYZ Racing wants to build a thoroughbred track or it could be a harness track, but say, for example, a thoroughbred track. And the commission goes through the process and issues the license, but they're not actually going to be able to build the facility for another year, and they wait. It seems pretty clear from what Attorney Commoners is saying that they can't have a sports book on their premises until they have live racing. And so my question was, I anticipate that we will get the question, all right, I know we can't do the sports book, but can we do the mobile app? So there's the issue of shall, the commission shall issue to a category 2 license under 23 and to any holder of a license to conduct live horse racing. But they can't operate it until live horse racing is conducted. So that present tense is, but then the question is there a way, and I'm just looking at page 5 of the statute, we'll look at it further. Are they able to utilize the category 3 license, particularly if there's a temporary license provision?
Karen, and thank you for that again. And I think it's important for us to also hear, and I think we might have been conflating some things, but that category 3 license, if it can be exercised upon an award of a horse racing application, our process that we would have to complete by November 15th, if whether or not their choice of an operator for mobile operations would be part of the final, or is it in addition to the final cap of 7 under the category 3? I thought it was my understanding that it would be an addition.
That's my understanding as well, yes.
And Paul, is that right? You're still thinking about this?
Let us run down this.
Yeah.
The status, the acquisition, and the use of these category 3 licenses in their entirety, and get back to you shortly.
Yeah, and thank you for everyone's patience as we go through this, but this is a big development on this process of our review of the application. The stakes have just shifted since the sports wagering has been legalized. Commissioners. So do we understand, Commissioner Skinner, did Karen answer your question? Is that helpful?
Yes, and I do understand the question and the implications.
Yeah, that's what I'm catching up on, along with all of you. So the idea that Director Wells presented is that today we could approve the application as set forth with the red line and accept red lines unless we have some editing to do. Move ahead so that would signal to potential applicants that they could get started, but that we would have a couple of matters to address on what will be a busy Thursday, and address any regulation that is needed for us to move on the application process as well as answer this fundamental question, not only for us, but truly for the public and any potential applicant. Commissioner O'Brien.
No,
Right.
it makes,
Oh, I just wondered, you had your audio off.
no, thought we were moving in for a landing.
Yeah,
So
we are.
What's talked about makes sense to me, and in particular, giving them time, Caitlin and Paul, time to circle back on any nuances we may have missed in this conversation.
Yeah, or in the review that we've done so far on the new statute.
Right.
It is not without complexity, so.
So Madam Chair, would we potentially, should the vote go that way, should we post this on the website with just a caveat that the commission would be adopting it formally after a reg has been established, but that the commission conditionally approved it?
Commissioners and Todd, I
Yeah.
see Commissioner Hill is nodding. Commissioner O'Brien says yes. Do we have a consensus that with the right caveats that legal can provide? Right? Commissioner Maynard, do you agree?
Yeah.
If we, again, I don't want to get too far ahead of us because I want to make sure every commissioner is really comfortable with moving ahead on the application, notwithstanding the two outstanding issues. Commissioner Maynard, do you have some concerns or questions you want to raise?
No, I mean, the application is to issue a new license to hold or conduct a racing meeting, The idea here is that applicant should want to race horses. That's my thought.
Commissioner Maynard is getting to a critical policy question here. We, and Commissioner O'Brien, you're nodding head. Do you want to weigh in on that point?
No, I that's what Commissioner Maynard just said.
So, Commissioner Maynard, do you want to elaborate? Sorry.
I think that it speaks for itself, right? The commission is undergoing a very serious process for standing up sports wagering. And an application for horse racing should be for horse racing. An application for sports wagering should be for sports wagering. That's my simple understanding.
Yeah, and so I guess maybe for me, because I'm appreciating what we're struggling with here. Councilor Grossman, in the application, is there room for conditions that should a licensee be given the opportunity to conduct sports wagering in advance of live racing, and that we know that this is still under further review. If horse racing doesn't happen, and it's a condition of their license, there would be a loss of a license or some condition that we would act on, correct?
Certainly, and I think there will be a series of conditions attached to any future award of a racing license, and that would certainly be one of them. But absolutely, getting horse racing up and running is objective number one. So yes, I do think that is probably the likely result.
So I think Commissioner Maynard's point is when we review this application, it is going to be about the details relating to horse racing, whether it can be around the corner or whether it's in the future. And that's what the application stresses. Yep. Commissioner Hill, do you have anything to add?
I'm thinking the same way Commissioner Maynard and Commissioner O'Brien is in regards to this. This is a horse racing application. I'm not going to continue debating it at this point. It's like, let's get moving and grooving. I love what you said. I thought we were bringing this in for a landing. I don't know how, but I'm going to use that in the future.
Okay, Commissioner Skinner, do you have any further questions?
I don't have any questions, just noting that I am in favor of moving forward on the application today. I think when you talk about conditions that can be attached to the license, those conditions are obviously going to fall in line with what how we read and interpret the language in the statute that speaks to the questions that are pending. So I think two separate discussions.
So thank you for everyone. And I, of course, do appreciate that this is on horse racing. But again, I think it's really important for us to be transparent about the implications, because some potential, someone may not have understood the implications, and again, we're going to get clarification of what this application can provide now that sports wagering has been legalized. So in order to be fully transparent, I think it's an important discussion to understand that there are implications under the new law for this particular, anyone who would be awarded a license pursuant to our application that we're looking at today. I think the application, if we hadn't had that complexity, probably I'd be a little bit less concerned and more willing to just immediately take flight. So thank you for indulging me. And I am ready to call the question if somebody wants to move, with the understanding we have some work to do for Thursday.
Madam Chair, I'm happy to propose a motion. Just before I do, if I could just check, Karen, the language that you're talking about in terms of the reg, what language would you think needs to be inserted in a motion to move on the app?
And I'll have Todd help me with this, but the thinking was that the commission move to accept the document as the application for horse racing, and that it
and the process will be subject to further regulatory action by the commission.
Right. So basically, it's like an anticipatory warrant. You basically approving it now, but it technically goes into you would technically have it go into effect once the regulation is passed, and that the public can rely on the actual document itself.
Okay. All right.
Is that right, Todd? I want to make sure our general counsel agrees with me.
Yeah, absolutely. No, I agree.
Okay. Madam Chair, I move that the commission approve the version of the new application for license to hold or conduct a racing meeting, which is included in the commissioner's packet, including the edits as discussed here today, which will be effective upon the execution of further regulation by this commission, and further authorize staff to make any necessary typographical or other non-material edits, and to post the application on the commission's website for immediate use.
Second.
Further questions? Discussion? Commissioner Skinner?
Oh, no, I was just.
Okay, you're just getting ready for the roll call. Okay, excellent. Commissioner O'Brien, we'll start with you.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. So thank you. And thank you for the work. And Paul, thank you for today jumping in, and thank you for the work you'll do over the next couple of days with Caitlin and team. It's always good to see you. Okay, thank you. I'm just going back to our agenda. So it is 11:05. I think it probably makes sense to take a break. But before I do so, we are anticipating executive sessions, and I understand that they would flow right into them, Todd. If the commission agrees to go into executive session, okay, then by law, I'm required to read the language that's in our agenda into the record. So the commission, and it will take a vote, anticipates that it will meet in executive session to review minutes, from previous executive sessions convened in accordance with General Laws, Chapter 30A, Section 21A3, in order for the Commission to discuss strategy with respect to litigation where such discussions at an open meeting may have a detrimental effect on the Commission's litigating position. In accordance with General Laws, Chapter 30A, Section 21A7, comply with GL Chapter 23K, Section 21A7, for the specific purpose of reviewing the proposed multi-year capital expenditure plan described in 205 CMR 139.09 and any corresponding materials submitted relative to Encore Boston Harbor and Plainridge Park Casino. As discussion of this matter in public may frustrate the purpose of the statute and associated legal authorities. And in accordance with General Laws, Chapter 30A and Section 21A6, to consider the lease of real property, as its discussion at an open meeting may have a detrimental effect on the negotiating position for the Commission. Then we have the minutes set forth, 110:22, 210:22, and 6:9:22. And we would, I think we would, do we need to vote on each separate, or can we move on all three, Todd?
I think it's okay to move on all three since you
I do
kind of
too. Thank you.
articulated everything.
Thank you. The Commission also, and at this point in time, it would be okay if the public does feel a little bit sorry for us. We have a long meeting ahead. The Commission anticipates that it will meet in executive session in accordance with General Laws, Chapter 30A, Section 21A3, to discuss strategy with respect to Massachusetts Gaming Commission versus Landmark American Insurance Company, as discussion at an open meeting law may have a detrimental effect on the litigating position of the Commission. And we have another piece of business to attend to today as well. The Commission also anticipates that it will meet in executive session in accordance with General Laws, Chapter 38, Section 21A3, to discuss strategy with respect to FBT Everett Realty LLC versus Massachusetts Gaming Commission, as discussion of an open meeting may have a detrimental effect on the litigating position of the Commission. So we do need to vote if anyone is willing to make a motion on our moving into executive session on those. It's actually multiple pieces of business, which we will tend to throughout the rest of the day.
Madam Chair, I move that the Commission go into executive session for the bases stated by the chair and for the reasons enunciated in the record.
Second.
Thank you. Any discussion on that? Okay, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. So again, so we will move into executive session on these multiple matters. I think it's really important for us to take a nice break right now. We thank all the team. Oh.
Madam Chair, did you want to point out that we won't be reconvening in public at the conclusion?
Yeah, and I thank you. And I was going to do that. I think it's important for us to take a break now, and we won't be convening again in the public. For the team, thank you for being part of this important racing discussion. Executive session will be limited. So I just want to make sure to thank all the members of the MGC team who've been part of this morning's important discussion. We also thank our guests who helped us on the matter, and also for the public's interest. We'll move into executive session, and I do think that we should probably plan on, it will go beyond lunch today. Todd, do you think that's fair?
That may be fair, yes.
Yeah, but we'll start with, it's 11:12. How about reconvening in, oh, I have to think about this. We will be exiting altogether this window and moving into our next virtual meeting, which you'll find on the calendar. And let's say we reconvene at 11:30. Does that make sense?
Yes.
Okay. I see everyone at the executive session at 11:30, and thank you again for everyone's input.